Ryan, let me know when you think that people are showing up, that we've let everyone in. Most people have their audio connected, and we'll go ahead and get started.
Advocates are always prompt and on time. I don't know what you're talking about. So we are ready to roll.
It's great. So Ryan's going to drop a document in the chat. This is a handout that we're going to be using. So no problem there. We'll drop it a couple of times. If you have some challenges downloading it, you can ask for help in the chat. I'm sure Ryan will be really responsive and help you out. So if we were all in person, I'd be handing out your papers, but instead you're going to get a digital paper. Good morning, everybody. My name is Carissa. I'm an AAG who represents the DCYF headquarters. I handled dependency and termination cases for about 5 years before coming into the role that I have now. Over in Yakima County. Anyone here from Yakima County? See some emojis or something if you're from Yakima. Well, great. Then I have a bunch of new friends. So thank you for joining this morning. What I'm going to do is talk about really the legal requirements for a termination of parental rights. So moving on to the second slide here, we're going to look at the statutes. What does Chapter 1334 require to terminate parental rights? And what does case law or cases, how do they interpret those statutes? What do they actually mean? We're going to do a high-level overview of the law that governs termination of parental rights. I will take questions as time allows, but we might be a little bit tight because the law is getting, thicker and thicker. There's more and more cases all the time that help interpret these elements. And then just as a heads up, what we're not covering today are aggravated circumstances cases. We're not going to discuss the presumptions that apply under one of the elements. We're not going to discuss the additional requirements for ICWA. We're not going to discuss due process constitutional requirements. This is strictly just what do the elements require and what do the cases that interpret those elements tell us. It's not because these other things aren't important, but this is just what we have time to dive into for purposes of today's presentation. So what do we know about basically for termination? Do I have any dancers? If you're a dancer, can you put like a thumbs up? Even if you're not like a professional, but do you go dancing? Do we have anybody who does that? Okay, we have a few, that's great. So one way that the termination statute is defined is like a two-step, like a dance move kind of, okay? So it's a two-step process, which is that all of the elements, these 6 elements in what we would call A through F, elements A through F, that's your 180 A through F. You have to prove those elements and that the parent's currently unfit by clear, cogent, and convincing evidence. And then you have to prove that termination of parental rights is in the child's best interest. So what's the take home that I want you to know from this slide? There's a bunch of information in it. What I want you to know is that the court doesn't consider what's in the child's best interest until all these elements are proven. This is the second step. You cannot start a dance on step 2, right? You've got to start at the beginning of the dance. And that's how this statute works. So hands up for anyone who has actually read through this statute that's on the screen here, RCW 1334-180, subsection 1, A through F, this statute here. Has anyone actually sat down and really read it? I have some honest people who are nodding no. I love honesty, radical honesty and vulnerability. Thank you. I have a couple people with a heads up. Okay, so that's actually what we're going to do first. Is I'm going to have Ryan break you into groups of maybe 3 or 4, or whatever he's done. What groups did you do, 2 or 3? You're on mute, Ryan, so we can't hear what you did. Anyway, Ryan's going to break you into some groups. Yes?
Yes, sorry. Breakout rooms.
And this is what I want you to do. That handout is your termination statute. I want you with your group to read through it. And I want you to talk about what you think those elements might mean, questions that you have about it. And I know that this is uncomfortable because a lot of you, this will be the first time that you're reading it. But the reason that I think that this is so important is because once you've actually read through it and tried to make sense of it, the information that we discuss is going to be more valuable to you, because you're going to say, oh, that was a question that I had, and now I understand why Chris is talking about that. Or, wow, I really interpreted this differently. I'm glad that I came to this presentation so that I understand what this means. So we're going to move you into some breakout groups here with the magic. If you want to download this paper, though, before this document, before we send you on your magical way to your workout groups on the Zoom space. So it's still in the chat. You can go ahead and grab that. Ryan also gave you a link to the handout online. You'll take this chat with you when you go to your room, so you can also open it up from there. So Ryan, I think we're ready for your magic. I hope that everyone's breakout room went well. Hopefully you have some questions that we're going to address, and you're realizing that the same thing that attorneys realize, which is when the legislature drafts a statute, it's not always clear what they're talking about. They don't always use language that's necessarily intuitive or that you really understand. So I am sure that that exercise was a little bit awkward, but I hope that it also prepared you and kind of primed your interest in some of the things that we're discussing today. And one of the things that I would also encourage you to think about as we go through these elements is, what do you think as a CASA or as a guardian ad litem or as an advocate, what are some questions that you would ask or information that you would want throughout the whole life of the dependency, knowing that if the case goes to termination, these are elements that need to be satisfied? And one of the comments that I received last time I gave this training, which was a really good comment, was that it kind of seemed to imply that, you know, the guardian ad litem or the advocate or the CASA is always in support of termination of parental rights. And that's a great comment that I want to kind of address at the forefront today, because if you're in a role where you don't agree with the termination of parental rights, what's the information that you're using throughout the life of the case to inform that opinion, right? It should be an opinion that's informed by the legal criteria that apply to the case. So these would be maybe questions that you're using throughout the life of the case as part of your independent investigation about whether or not you would recommend the termination of parental rights for a case. And remember that termination of parental rights is not a permanency plan, right? It is the way that you would achieve the permanency plan of adoption. But termination of parental rights itself, that's not a permanent plan. So with that, we will go ahead and we will dive in and let's see what some of these elements require, what the court has told us about them. So the first three elements that are on your worksheet there, we would call those elements A, B, and C. These are pretty much almost always uncontested, and you're not really going to have a trial about them. So the first one is that the child has been found to be dependent. And so here I have, this is the caption, what we would call the caption of a court order. It says order of dependency. So there should be an order that's been entered for the child as to this parent, the parent's rights who may be terminated. There needs to be an order finding the child dependent as to that parent. Also, the court has to have entered a dispositional order pursuant to RCW 1334-130. That statute is just the dispositional statute. It tells the court when it has to have the dispositional hearing and what it has to address in that. And you'll see that this order shows up one of two ways, generally speaking, in your cases. One is with the caption here. You'll see this yellow highlighted part says disposition order included. So if I go back a slide, you can see that box actually exists on this caption too. It's just not highlighted in yellow. So if that box is checked, sometimes it's not checked because people, AAGs, draft the order sloppy. And it should be checked because the whole disposition part of the order is filled out, so you may need to look at that. And in some of your cases, you may actually have a separate disposition hearing, in which case there'd be a separate order, not a combined order that's entered, and that's this caption over here on the right, order of disposition on dependency. So you can check to see that those orders have been entered, and the termination petition should allege that those elements are satisfied and usually include the dates too. Okay, so the other element here is that the child has been removed or will, at the time of the hearing, have been removed from the custody of the parent for a period of at least 6 months pursuant to a finding of dependency. Okay, so what does this mean? Let's say that you have a child who's removed from the home and you have a shelter care hearing, and then for a variety of different reasons, substitution of a bunch of counsel, maybe COVID happens, a bunch of different reasons delay the dependency fact finding. So the child isn't found dependent for a year. So a year later, the child's found dependent. What's the soonest that you could have that termination trial for that child?
6 months after the establishment of the dependency.
Yes, gold star too. Is it Carissa?
Yes.
Carissa. Yeah, gold star. So it's not how long the child's been removed. You have to meet this element by saying that the child has been removed from the custody of the parent for 6 months pursuant to the finding of dependency. So if that dependency fact finding gets continued way out, the soonest that termination of parental rights could occur also gets pushed out. These elements are usually not contested at the trial, and the reason is because they're pretty factual. The order of dependency was either entered or it wasn't. The order of disposition was either entered or it wasn't. 6 months have passed or they haven't, right? There isn't a lot to interpret there. So there's very little case law, and these are very, very seldom contested. So the more interesting elements are the ones that follow. So here's our D element, what we would say. The services ordered under RCW 1334-136 have been expressly and understandably offered or provided, and all necessary services reasonably available, capable of correcting the parental deficiencies within the foreseeable future, have been expressly and understandably offered or provided. This is a total mouthful, and it's really hard to know what this means. So we're going to go ahead and break this down and talk about it a little more. So services ordered under 1334-136. That's the citation for the permanency plan statute. So the services that are ordered there have to have been expressly and understandably offered or provided. How would you know whether a service has been expressly or understandably offered or provided to a parent? Anyone?
The parent has used the service.
Say that again.
If the parent has used the service.
Okay, great. So if the parent goes to the service, obviously they understood that it was offered and then it was provided, maybe, if the parent continued showing up. Great. How else? What if a parent doesn't?
Can also show service letters, monthly service letters.
Okay, great. So maybe if the worker sent the parent a letter telling them about the service, what information would you want to see in that letter in order to make sure that the service was expressly and understandably offered or provided?
Phone numbers to contact the correct name of the service provider, and phone numbers and what the service was.
And
that's a great
also,
suggestion.
And also in that letter, you would want to be sure that you say something to the parent, like, if you don't understand what this means, please contact your social worker with all the right information. So you've made it clear to them that they need to understand this. And if they don't, they need to let someone know, because otherwise, it's normally clear.
That's helpful. Great.
Wouldn't the first place to see this would be in the court orders in the disposition, right? Because at least we would have a record that the services were ordered at least. Is that true or not?
Right. So whether the service is ordered, but then it still has to be expressly and understandably offered or provided.
I see.
Right.
I've heard of the judge actually ask the parent directly in court, do you have any questions and do you understand what we're asking you to do?
Mm-hmm.
And they've responded in court, yes, I do, I understand.
Great. That should get in the court order then. Otherwise, it didn't happen, right? Because it's going to be a lot harder to prove. I guess you could still probably admit it, but.
I would also want to look at the content of the information to see that it's been offered in a way in which the parent comprehends that information or is receiving that service. Because oftentimes it's the services provided, but this parent may have like other cognitive deficits, or they may have some learning disabilities, and making sure that that service is provided at that level in which the parent gets the information.
Mm-hmm. That's great. What if the parent doesn't speak English, or English isn't their first language?
I wanted to go to that, to the whole question of language, and indeed, can the parent read, and is the parent not blind? And you really have to assess from the parent that they have understood the offer. Right.
That's great, Brian. I think that's a great summary, right, of what we're getting at here. I think personally, this is not like the AGO's position or every AAG's position, but I think one of the best ways of understanding whether a parent really understands what's offered or provided isn't just that they say that they understand, but they can explain it back to you. Like, what are the services that you're supposed to be doing? How do you access those services? Who do you need to call, right, to get that? We're going to go over that. And how many of you have been to a shared planning meeting before? Sometimes those are called like an FTDM, permanency planning, staffing. Yes, exactly. Those are all places where you should be discussing what needs to happen in the case, what's been done and what hasn't been done, right? Those are great opportunities to also have these conversations, because delaying the provision of services to a parent is not in the child's best interest, because it delays the case. Either you can't go to termination because it hasn't been expressly and understandably offered or provided. The kid can't get home because the parent doesn't understand and have access to the services that they need for a successful reunification. So knowing this part, remember, we haven't even gone through the whole element yet. We're just at the first part of this element. What are some questions or some things through your independent investigation during the case that you may want to ask the parent or take note of or address throughout the case to that relates to this part of this element? Brian, you want to unmute yourself?
Sorry, does the parent know the telephone number and know what will happen if they call that telephone number and who they're going to speak to? And is the parent capable of taking the first steps to get into the process?
Right. So you want to have discussions with the parent throughout the case, and unless there's a court order, right, that prohibits you from having that communication, but to know whether or not they really understand what services are being offered and what services have been ordered for them. Right. Let's move along here. So we have all this part, and
I'm sorry.
Yes, Vicki.
I have a quick question. If a parent has started a service, for example, they started taking a parenting class, and then they drop out, and you say to them, you need to contact these people again, and you're registered for this class. Is that a reasonable assumption that they understand what they need to do because they did it before?
I think it just, again, it's going to come back kind of what Brian said. It's really the facts and the circumstances, right? So did they understand that they told them that this service, they couldn't go to the service anymore? Did they get kicked out because of behaviors? But certainly if the parent has set up a service before, then presumably they understood how to do that. But also maybe they weren't the ones who set it up, right? So you just want to make sure that they really do understand. It's been expressed and it's understandable what services are being offered or provided to them. So there's what we have here. Jimmy?
Yeah, so one other thing, a request for information, wouldn't we have to have that filled out also by the parent so that we could talk to the service providers?
I think that's going to depend a lot on how your county operates and what's in your form orders. So some of you will have access to things maybe more easily. And you'll want to, maybe talk to the providers as part of your investigation as well. But I'm talking about really the front end. How do we know that they even knew that that service was offered or provided? If they're going to the service, they understand it's offered or provided because they got there. But what about parents who don't engage in the service? How do you know that they really understood what was being offered or what they were court-ordered to do? So we have this part that services ordered under the permanency plan of care have been expressly and understandably offered or provided, and also have to prove that all necessary services reasonably available, capable of correcting parental deficiencies within the foreseeable future, have been expressly and understandably offered or provided. This is a huge mouthful. We've already talked about expressly and understandably offered or provided, but what does this mean? So it's services that are court-ordered under the permanency plan of care, but also all necessary services. So the department has to prove that the parent understood that they received all court-ordered services and all necessary services. Well, what is a necessary service? The court tells us that it's a service that's needed to address the condition that precludes reunification. So a service that's needed to address the condition that precludes reunification. So if you're going to go up there and say one of the parental deficiencies is that this parent has a chemical dependency problem that interferes with their ability to safely and capably parent this child, what's the service that needed to be offered or provided?
Rehab.
Chemical dependency treatment, exactly, Anne. What about if it wasn't court-ordered for some reason? Does it matter?
No.
It doesn't matter because the department has to provide all court-ordered services and all necessary services. So if that service is necessary, it better have been offered, offered or provided in an express and understandable way. Even if the parent doesn't want to engage in it, it has to be offered if it's a necessary service. So the service also has. Alice?
Sorry.
You're okay.
What about housing, transportation, a job?
So housing and transportation and those things, housing is a little bit messier. We're not going to dive into that one today. It's like got a whole different subset of some cases and things to address. But remember that service as used here is a remedial service. So it's a time limited service. It's not a permanent support that would be in place forever. It's a service that's needed to address the condition that precludes reunification. It's not a service that essentially resolves the condition, right? Like, okay, now you have a nanny to supervise your kids. Well, if that's not if the condition that precludes reunification is that the parent doesn't have the parenting skills or the attention or ability to adequately supervise the child, so the child's falling and getting injured, climbing up on things, running out into the street, right? The service needs to address those parenting skills and the ability to supervise the child and understand safety threats, right? The service isn't that remedies that is not someone else comes in and supervises the kid. So that's a good question though. So I think you want to ask about that piece. What is the service? There's also an aspect of futility here. So there is some case law that says that, if the parent didn't engage in a lot of their services, basically, the department doesn't have to do more. So if it would have been futile to provide the service, then the department doesn't have to provide it. That's really, I think, a twist on this part that says, it's capable of correcting the parental deficiencies within the foreseeable future. So if the service isn't capable of correcting the parental deficiencies within the foreseeable future, then it doesn't have to have been provided. But this case here, NRA matter of BP, also tells us that the parent isn't required to prove that services would succeed before the state's required to provide them. So it's better to just provide the service and have an opportunity for it. So in BP, the issue in that case was attachment services. that were determined to be necessary to preclude that condition that prevented the reunification. And the court disagreed with the court below. The Supreme Court disagreed with the court below and said, that wasn't futile. So the evidence presented showed that the services might not be successful, but the mother had participated in all of the other services, in her mental health services. The court didn't find that substance abuse or mental health were continuing barriers to reunification. And so where the parent had engaged in all these services, the state doesn't just get to say, well, we're pretty sure that this relationship was so broken that it couldn't have been repaired. Instead, the state had to try and had to provide that service. And then the court could determine whether or not it was successful to remedy that condition. So reasonably available services, what does that mean? Especially, I think someone in my breakout group was talking about COVID. I agree, that has made this way more challenging in terms of reasonably available. But traditionally, so there's an aspect of the RCW that requires the department, if there's a service, the court-ordered service that they can't provide, to go back to the court and let the court know, like, we're not able to provide this service, and explain why. And so if that's that should happen, in my opinion, earlier in the case. You shouldn't be addressing this at the termination trial. If the service isn't available, you should go back to the court and have it removed from the case plan.
Carissa, what about something like, when you say reasonably available, what about a geographic accessibility problem where parents are told, okay, you need to do random UAs and here's where you're being directed, and that location is just too difficult to get to?
Right. I think that should get addressed in the dependency, and it should get addressed early on. Those are all arguments that you're going to see in the termination, but in my opinion, what I want you to be thinking about is, like, this is creating a problem way down the line, because either this case can't go to termination, or it's precluding, being able to get the child home. So, you don't want to wait to address these issues until you're on the eve of the termination trial, or you're even dealing with them in the appeal of the termination trial. So I think what I would look at there is the UA a necessary service? And if it's not reasonably available, what else could be put in place? And that's a discussion to have with the caseworker if you're concerned about it. Maybe there could be a hair follicle test that's done at certain times. It's going to depend on the type of substances that you're testing for, because and what the real issue is, if it's habitual use or if it's occasional use. Is the concern occasional use because the parent is bringing around individuals who are really unsafe into the home environment and doesn't understand that, and that's like an aspect of the problem? Or is it really habitual use? So like a UA is going to be better at detecting a one-time use. Hair follicle, from my basic understanding, is that, and I'm not a toxicologist, but that it will show more habitual use. So a hair follicle is not going to show whether or not a parent did or did not use within the last 72 hours. But it might show whether or not there was habitual use over the last, whatever the window of detection is. I can't recall it off the top of my head. So there's a lot of aspects of this element that are woven in that all have to be proven for just element D. And remember, this is the first usually contested element. So what are some questions or some things that you would be paying attention to throughout the case to either flag as an issue or to determine whether or not you think this element is going to be satisfied at a trial? One question, are there any other services that or supports that you think you need in order to get your child returned home to you, right? Because if they say, yeah, you know what, I think I need some counseling. I'm just noticing that I'm depressed and I'm having a hard time engaging in my case plan because I can't kind of get over this barrier of being depressed. Is that a necessary service, even if it's not court ordered? Maybe, possibly.
I would also think the social worker needs to be consulted about whether there's something that could conceivably be called necessary that was not in the court order.
Right, so those are some discussions you can have with the caseworker too. Oftentimes where I see the necessary piece come up is where the department asks the parent, the court to order a service and the court doesn't order it. So the department will say, well, we're still offering it because we still think that it is necessary. So I had a case once, for example, where the court said that, found that the parent didn't have a chemical dependency problem that was interfering with their ability to parent. The department just really disagreed with that for a variety of reasons. And so we continued to make it really clear in that case, look, we understand that the court has not ordered you to participate in chemical dependency services. The department thinks that you have a serious addiction to marijuana that's impacting your ability to have your kids returned. And we're continuing to offer, the department's continuing to offer you chemical dependency treatment and recommends that you participate in it, but it's not court ordered. And we're putting on notice that we still think this is a parental deficiency, and we're continuing to offer that service over and over and over again, because if it's not offered, how are you going to rely on that as a condition that precludes reunification at a trial if you haven't offered a service that can remedy it, right? So there's this connection that continues. And having this perspective early on in the case is really important so that we don't delay permanency, whether it is delaying reunification because the services haven't been put in place in the right way, understandably early enough, or it delays reunification because the service wasn't put in place and now you can't go to termination because you now need to offer it.
I have a question. So if it is not ordered, but you still, the department still thinks it is a necessary service at termination, why would a service that has not been ordered for the parent to take be an issue? So even if the department thinks that they should have this service, but the court has not ordered it and is not making them do it, would that have any bearing on the termination that they didn't take this, that they didn't do the service?
Right. Patricia, this is a good question, and I'm actually going to put a pin in it because I think it relates to another element that we're going to discuss.
Okay, thank you.
So we're going to get back to it, and I love that you're foreshadowing that. So we're going to move on to the next element here. Okay, so there was a case that came out from the Supreme Court this year, MASC, and this gets at a comment that I think Brian made about, you don't know the parents, maybe their intellectual capacity or abilities when you're offering a service. So where the department has reason to believe that a parent may have an intellectual disability, it must make reasonable efforts to ascertain whether the parent does in fact have an intellectual disability. And if so, how that disability could interfere with the parent's capacity to understand the department's offer of services. So if the department has reason to believe the parent may have an intellectual disability, the department needs to make reasonable efforts to figure out, does the parent actually have an intellectual disability? And does this disability present in a way that could interfere with the parent's ability to understand what's being offered? So reasonable efforts will be evaluated from the perspective of a, quote, objective observer who's aware of the nature and the extent of the parent's intellectual disability and the current professional guidelines for communication with people who have similar disabilities. I don't know what that means. We haven't had any cases that interpret that. The department's working on implementing it. But what it does tell you is that you should have somebody who's a professional who's, familiar with some aspect of this parent's intellectual disability weighing in and making sure that things are understandable. And then the department also must tailor the offer of services to the parent in a way that's reasonably understandable and informed by current professional guidelines. So here, this isn't only getting at informing the parent that there is an offer of services, but also how the service itself is offered when the parent engages in it. So, for example, maybe the parent is going to a parenting class, and that class has like a little workbook, and people have to do their homework and bring it back to the parenting class, and then they work in a group, and then there's some other work. So that's like a group class with a workbook. Well, for some parents, that is not going to be a way that they can absorb information, particularly if they have a learning disability that where they don't read and retain information well. Maybe the parent, because of an intellectual disability, needs more modeling, that someone shows the skill rather than describes it and then has them practice the skill. And so the service may need to be tailored or refined differently in order for the parent to be able to get the benefit from it. And so that's what this is getting at here. So how do you know if the parent has an intellectual how do you know if there is reason to believe, that's language from the case, that a parent may have an intellectual disability? What are some things that would tell you that? Well, I can just tell you what happened in this court case, because this court case is pretty new, so we don't have cases that are like really implementing it yet. But information in MASC that the court said gave the department a reason to believe that the parent here may have an intellectual disability, or that the department here in Washington had contacts with the child welfare authorities in Oregon, where the family had previously been involved. And there was some collateral information in there about the parent, I think, maybe having some cognitive functioning. And the dependency order stated that the mother was clearly struggling with her cognitive faculties. So that was more than enough, the court found, to trigger DCYF duty to ascertain and accommodate the mother's needs. So if you have information about the parent received maybe like special education services, or the parent has told you that they've been diagnosed with, a learning disability or something along those lines, those are all important things that you want to bring up soon in the case so that they can be accommodated and the parent can learn the skills that they need to have the child returned home, or so that if necessary, so that if the case does go to termination, then can achieve permanency for the child.
Carissa, sorry.
I was going to say, I just got assigned to a case this morning where the mother had to have part of her brain removed. And with that became a personality change. And she's now incarcerated and the child's been in foster care for a while. How would you, or what would you do with that to help in figuring out what she can or can't do and what she can and is liable for doing?
Well, I think that that's what the case tells us, is that the department must make reasonable efforts to ascertain whether in fact she does have a disability, and if so, how it could interfere with her capacity to understand the department's offer of services. So we're not going to go into a bunch of different like case staffings, I totally understand, but that's, this is the guidance or the direction that the court has given. A mental health condition, this case doesn't really cover, Nancy, but there are some different obligations under the Americans with Disabilities Act that are kind of outside the scope here. So this is still, we're still in element D. You had a question like, what are some of the issues that parent attorneys usually raise? Typically what will be raised is that the department didn't offer a necessary service, even if it wasn't court ordered. So we'll talk about that a little bit more, like I said, in response to Patricia's question. All right, so much talking. Okay, I'm going to take a drink of water as we move on to element E. So the other element that has to be proven is that there's little likelihood conditions will be remedied, so the child can be returned home to the parent in the near future. What is the near future, and how would you measure this? Does anyone have ideas? Anybody come up with this in their group?
I guess the next scheduled court date, 6 months.
Say it again, Alice. Come off mute one more time and say it again.
The next scheduled court date or 6 months.
Why? So you think that that's the near future?
I'm throwing that out as a possibility.
Throwing it out. Okay. Yep. Got it. Perfect. Okay. Thank you for throwing out an idea, Chrislana, I think you had something to say too.
So what if maybe it also depends on the type of service, like how long would it then take them to get into an intake and then get the appointment going and get the services going, and how far out would that be? Would be something else that I would think about as far as a timeline.
Right, so you're both talking about different timelines and both of them are relevant to satisfaction of this element. So Chrislana, you're talking about how long is it going to take for conditions to be remedied? So parent goes to an evaluation and the assessor says, I think that this person needs 2 years of this type of treatment. So that's part of your discussion of how long it's going to take for conditions to be remedied so the child can be returned home. And then we have what is the near future. So you're comparing these, what's the time that it takes for conditions to be remedied and what's the near future from the child's perspective? And what's the likelihood that this can happen, that the conditions can be remedied in the near future? But how do we measure this part? How do we measure the near future? So the court tells us that we measure the near future from the child's perspective. And it's from this specific child. It's not just from a 4-year-old, a 6-year-old, a 12-year-old. It's this specific child and this child's development. So what are some things that you would want to do in your interactions with the case to know or evaluate whether or not, what's the near future for this child?
Would be concerned about what kind of bond does this child have with the parent? If, for example, I have a case where the child has never lived with the parent and the parent's visits have been very sporadic and the child will soon be 2. To me, the near future would be a relatively short time because this child's life is progressing. This parent really plays no meaningful role. And at a certain point to say, we're going to move this child back to be with this parent, it is incredibly disrupting. So I would think in that kind of a case, it would be a relatively short period of time. I mean, as a matter of months, if it's met the 6-month requirement and the case goes to, the department thinks it's time to file a termination. If the parent is not currently working hard in services, I would think you've got a good case, but that's.
Right, so Vicki, the court tells us that the near future is evaluated by the child's perspective. So how would you, in that case that you came up with, how would you provide testimony about what's the near future from a 2-year-old's perspective? I think you said a 2-year-old.
He not quite 2. Yes.
Okay.
I mean, from what I understand of children, the near future is tomorrow. I mean, it's extraordinarily short to say.
Right, that can't be for children that age. So what are some things that other people would do? I'm going to build off of Vicki's hypothetical here for our demonstration purposes. So what are some things that you would do when you meet with this almost 2-year-old to provide some testimony to the court about the near future from the child's perspective? I think you'd ask the child some questions, right? And see what are they thinking about? What are they really perceiving as the near future? What are you, so you could say, like, what are you looking forward to that's coming up soon, coming up in the near future? And if they're like, we're having pizza for dinner, that's really different than an answer that you might get that's like, oh, I'm really looking forward to Christmas. I'm looking forward to trick-or-treating. I'm looking forward to Christmas, right? Like those are different timetables. It kind of gives you an idea from having this interaction with the child. And then you also want to make sure, like Chrislana pointed out, that you're getting that the court record is showing how long is it going to take for the conditions to be remedied. So making sure that providers are asked, how long it might take if the parent were to fully engage in this service to remedy this issue. I remember for one of my very first termination trials, I think I forgot to ask that question, which isn't like fatal, But I was really grateful because I had an experienced guardian ad litem on my case, and they asked that. So this idea of like what's the near future from the child's perspective is a little bit mushy. But what I did was I pulled out like what have courts upheld on this element. So this is not a finding that 6 months is not the near future for a 15-month-old. That's not what the court held there. What happened in that case and the rest of the cases is the court affirmed the trial court's finding. So this doesn't mean that for every, excuse me, every 15-month-old, anything over 6 months is not permissible. Because remember, it's based on the specific child. But this gives you an idea here of what the courts have upheld on this in other appeals. So you can see the different time frames.
Carissa, what if there is, just again, looking from the child's perspective, an upcoming important transition like starting kindergarten, you know, and you can say, okay, in terms of near future, I'm going to define it as this child is starting kindergarten. It's a very important transition. We want them to be able to start and stay in a school and join a school community. Is that kind of thing part of a definition of near future?
Well, it's really from the child's perspective. So it's not, remember, we're not talking about best interest. So if you think that that event coincides with the near future, then you would say, like, for example, I think it's 3 months and this is why. But it wouldn't just be the transition itself, because I think some of the rationale there, while totally understandable, is really more about best interest. And remember, we're still on the first step of our two-step dance to prove to prove the elements necessary for a termination of parental rights.
I understand it's for each child as individual, but as a basic rule of thumb, you could say the younger the child, the shorter the time frame.
Generally speaking, that's probably true. A child who has development that's not neurotypical, right, might be lower on that, but I think that's generally true.
Carissa, this is Cheryl. I'm sorry, I don't totally understand this slide. Were these courts saying that 6 months was too long to be the near future?
Which bullet? Are you looking at the first bullet?
I'm looking at all of them. They're all saying 6 months is not the near future. Does that mean 6 months was too long to be the near future, or 6 months was too short? Okay.
Right. So what I could surmise from this, because I haven't looked up this case recently, is that probably what happened here is they said, well, it will be at least 6 months before the parent can remedy the conditions that are needed for the child to go home. And 6 months is not in the near future from the 15-month-old. So that element is satisfied. There's little likelihood that the conditions can be remedied in the near future from this child's perspective, because they'll take at least 6 months, and that's not in the near future. It'll take at least 1 year, and that's not in the near future of a 3-year-old. It'll take at least 8 months, and that's not in the foreseeable future of a 4-year-old. You know, it'll take at least 1 year, and that's not in the future of the 6-year-old. And you can kind of go down the list that way. And so again, this doesn't hold that 1 year is never in the near future for a 6-year-old, but it gives you a sense of what the court has found to be credible and to affirm that on the appeal. So yeah, mixing foreseeable future and near future. The statute does use different terms, but generally speaking, they're kind of evaluated the same way, Betty. That is a very good question and very perceptive to bring up. So, and Mike, yeah, I see your suggestion. I just asking things about time. I think that makes sense. What are you looking forward to when you talk with the child? What are they thinking about, right? And getting a sense of what is their near future. What are they able to consider and think about? Okay, we're almost to element F. We're almost to the end of our first step. So element F, that continuation of the parent and child relationship clearly diminishes the child's prospects for early integration into a stable and permanent home. So again, a bunch of things that are not defined and kind of challenging to capture. What is the parent and child relationship that's at issue here? Or that's the court talking, is this element really relating to like a bond? What is this talking about? So what's at issue here is this element talks really about the legal parent-child relationship. So when we look at this element, we're talking about continuing the legal parent-child relationship. Even if there isn't a bond or a personal relationship between them, they still have a legal relationship of parent and child. And it relates to this child specifically, not children in general. So you'll be looking at what are this child's prospects for early integration into a stable and permanent home. And so one thing that I think is good to think about is what is the difference between stability and permanency? Because this says into a stable and a permanent home. Anyone have thoughts about how stability and permanency might be different?
You could have a permanent home that's very unstable. Parents are in and out. The kid never knows what's going to happen from one day to the next. It can be a permanent placement, but maybe very unstable. Okay, so Vicki, you're talking about like the home itself and whether or not inside the home and the way that the family is managed has stability. Yes.
What if you have a stable situation in which a child's physical needs are being met and they're safe and they're being fed, but there's not really any formation of emotional attachment, which is something you would hope to see in a permanent home. I don't know what distinction you're going for. That just
Yeah, that could maybe be. I mean, I think one of the things here is that, you can have a very stable placement, but it's not a permanent placement because the parental rights are still intact. So you can have a child who's been placed in the same home with a relative even for a very long time, and it's really stable, and they're willing to be a long-term placement for the child, but that doesn't mean that the placement is permanent, right? Because the dependency is ongoing, the child's still legally in the custody of the state. And so sometimes you'll hear an argument that's like, well, the child's doing fine, the child's stable, everything's fine, they don't need permanency. But this says a stable and a permanent home. And so it's important to evaluate both aspects of it. Is the placement if the placement is stable, placement would also need to become permanent. That's one of the things that we're talking about in this element. And one of the other things to really consider here is, right, being able to articulate why is adoption the best permanent plan for this child? Because the purpose of doing a termination of parental rights is to achieve an adoption. So why is that the best plan here, as opposed to other permanency arrangements, like a guardianship, for example? Why is that an inferior plan for this child? And to be able to address that. So the cases tell us that there's really two ways to prove this element. The first way is to say that prospects for a permanent home exist. So maybe the child's in a pre-adoptive placement. So there's prospects for a permanent home, but the legal parent-child relationship prevents the child from obtaining that permanent placement. So it's mainly concerned with the continued effect of that legal parent-child relationship. And that legal parent-child relationship is itself the obstacle to achieving adoption, which would be the permanent plan. The other way that this element can be proven is that the parent-child relationship has a damaging and destabilizing effect on the child that would negatively impact the child's ability to integrate into any permanent and stable placement. So maybe the ongoing contact with the parent due to severe trauma or abuse that the child has suffered destabilizes the child and makes them unable to bond with any other placement. And so they really don't have very good prospects right now for integrating into a stable and permanent home. They're not in a pre-adoptive home, but maintaining the legal parent-child relationship is damaging the child and is destabilizing them. And so to have their prospects to integrate into a stable and permanent home, the parent-child relationship needs to be terminated. Those are pretty much the two ways to prove that element. Okay, so this is the second part of element F. So we did this first part, continuation of the parent-child relationship, diminishing the child's prospects for early integration into a stable and permanent home. And then there's this other part. If the parent is incarcerated, then the court has to do more things. It has to consider whether the parent maintains a meaningful role in the child's life based on factors in one of the statutes. It has to consider whether the department made reasonable efforts as defined in the chapter, even though reasonable efforts isn't defined. So that part doesn't really make sense. And then the court needs to consider whether or not particular barriers existed as described in this statute, including but not limited to delays or barriers experienced in keeping the agency apprised of their location and accessing visitation or other meaningful contact with the child. So if the parent is incarcerated, the court has to make these different considerations. So we had a case that went all up to the Supreme Court, and it was, what is incarcerated? What does is mean was basically that case. Whether or not it meant if the parent is incarcerated at some point during the case, or whether it meant if the parent is incarcerated at the time that the termination order takes effect. And so the court in that case found that is means is, and it means that if the parent is incarcerated at the time that the order is entered, not if the parent is incarcerated at some point in the case. So this part of the statute applies if the parent is incarcerated. This would mean, though, if a parent gets incarcerated like partway through a trial or before the order is entered, when the order is entered, like these elements, or this, sorry, they're not elements, but the court needs to make these considerations. The other case that we had is, what does it mean for the court to consider? And so these two cases basically found that this element requires courts to consider those listed considerations, but they don't compel the conclusion that termination isn't warranted, and that considering doesn't require individual findings for each one of those considerations. The court must consider the factors. Explicit findings are not necessary, although they would be helpful. So it's nice to have them. So the court doesn't have to find each of these elements, but you do need to have some kind of evidence that the court considered these considerations. And then the case law also tells us that even if all of these are in the parent's favor, the court can still find that this element, element F, is satisfied. It doesn't mean that if all of these considerations are favorable to the parent, that the element cannot be proven.
Okay. This is Sharon. May I ask a question?
Sure, Sharon.
So I have a case where a child's been in foster care with...
Oh, but we're not doing specific cases. Remember, we're not staffing cases. Do you have a general question that you want to ask?
Yeah, if the parent has been incarcerated for the child's entire life, and the other parent is not involved, so there's a very possible adoptive situation, and then the incarcerated parent gets out. I mean, how do we then look at that parent from that point on? I guess I'm just wondering, how can you tell whether the incarcerated parent could possibly become a placement for a child they had never even met?
Well, it's going to be totally specific to that parent's parental deficiencies, right? What do they need to do? And what's going on? So you're going to evaluate it just like you would for pretty much any other parent. They may need a little bit more time to engage in some services and see whether or not they're able to make progress quickly. But it's not going to really be it's not going to change the way that element F is proven.
So
right?
So as I understand it, if either parent is available, you don't terminate. So the timing would begin at the point when the person is no longer incarcerated, meaning it could go for, another several years while we see
What do
whether
you
that.
mean there's no termination if the parent is available?
Well, when you have one parent that's completely not participating and completely out of the picture, but the other one is incarcerated and expressing a desire and will be getting out fairly quickly now, but has never even met the child. So it's a very young child. So, I mean, I guess I just, what bothers me about this is that this child, her sense of the near future when you're 3 years old is like you said, I want bananas for lunch. But because the fact that we're kind of dealing with each parent sequentially and not at the same time, rather than her permanent plan be set, within a year or two, now we're looking at, potentially like 6 years.
Well, I'm not sure. I mean, we haven't discussed anything that says that you would look at each parent, sequentially. I think for that parent, what you're going to do is you're going to go through all of the elements and assess it and see whether or not there's little likelihood that conditions can be remedied in the near future from the child's perspective with that parent, whether or not continuation of the parent and child relationship clearly diminishes the child's prospects for early integration into a stable and permanent home. If the parent's still incarcerated at the time of the trial, the court's going to make these considerations, which aren't determinative, but the court needs to make them, needs to be clear on the record that they did, and whether all services that were court-ordered and that were necessary and reasonably available were offered or provided to the parent. So, we're not through all of our elements yet, but you're going to do the same thing. You're going to take that case and that parent under those situations and that child and go through the factors, to prove termination of parental rights and see whether or not the case is legally sufficient. And it's possible that the case is legally sufficient, but the department doesn't want to proceed yet because it wants a stronger case maybe, or wants to see if the child can go home because it might be faster than dealing with the appeal. So there's other considerations that the department might have. But from a legal perspective, you would do the same thing. You take that parent and you go all the way through. But there isn't anything in the case law that says that you have to deal with the parent sequentially for a termination of parental rights.
Okay, but I mean, if there's no relationship, then you kind of are forced into it. If a child is too young to really have a relationship or it's very superficial over Zoom.
Well, the relationship's relevant to some of the factors, but I wouldn't say that that's determinative for everything, right? So you're going to do the same thing. You're going to take that case, and when we're done, you're going to roll through this presentation. You're going to look at all of the different the ways that things are interpreted, and you're going to kind of evaluate where are the weak points and where are the strong points.
So can I step in here for just a second? Yeah, I have had a case that this is describing completely. Can't give specifics, but the parent that was incarcerated did show interest in the court proceedings and did what they needed to, and the child was placed with them. Mm-hmm. And that's even out of state too. So not in Washington. So it can happen.
Yep. Yeah. So we only have about 12 minutes left, so I'm going to go through and at least get through the remainder of our slides. And then if there's time for some more questions, we'll go ahead and take those. So what are these factors that the court needs to consider? So again, if the parent's incarcerated, the court also has to consider these things. And it says, whether the parent maintains a meaningful role based on the factors in this statute, whether particular barriers existed as described in the same statute. So what does that statute talk about? So those factors that the court needs to look at and consider are the parent's expressions of acts of manifesting concern for the child. Those could be letters, phone calls, other communication. The parent's efforts to communicate and work with the department or others to comply with services and to maintain or build the parent-child relationship. The parent's positive response to DCYF's reasonable efforts. Other information that's provided, that could be maybe from a CASA or a GAL, as well as parent attorneys, correctional personnel, mental health providers, service providers, limitations on the parent's access to family support programs or therapeutic services or visitation opportunities or mail, or to participate in shared planning meetings and the attorney, or court proceedings, all of those things. and then whether it's continued involvement of the parent in the child's life is in the child's best interest. So I know I told you the court doesn't get to consider best interest until the second step, but the court can consider best interest for an incarcerated parent in the context of element F. But again, these are just considerations. They don't end up proving or disproving this element. It's just information the court has to consider in determining whether or not this element is or is not satisfied. Okay, so these are all things information that's going to need to come before the court in the termination trial so that the court can consider that information when deciding whether or not the element is satisfied. So we got through all of the elements A, B, C, D, E, and F, but then there's another secret element, which is current parental unfitness. And this is not expressly in the statute. That's why I called it the secret element. But it is required by due process, and it has been articulated this way under case law. So this isn't whether the parent's unfit in general, but it's unfitness to parent this child and meet the needs of this specific child. And so it also includes knowing what the child's needs are. So you need to make sure the court is informed about the child's needs. It is not a comparison about whether or not the biological parent is better than the foster parent. So and the K&M case is one of the cases that really addresses current parental unfitness. It talks about how a parent may be found unfit when they're unable to parent the child due to the child's lack of attachment and bonding, and there's an inability to remedy that attachment. This was a very extreme case, though, and so I don't want you to think that anytime there's a lack of bond, you can just prove current parental unfitness outright. But you do need to prove that the parent is currently unfit to parent this child. And so the reason, this goes back to Patricia's question from way before that I told her we had to put a pin in. If you have to prove current parental unfitness, you have to say these are the reasons the parent is currently unfit. These are the reasons the child cannot be returned home. These are the reasons that termination of parental rights needs to be granted because the parent is currently unfit. Then you better make sure that there's a service, necessary services have been provided, even if not court ordered, to support the reason that the parent's currently unfit. So it wouldn't be advisable, for example, if the parent hadn't received any service for something, to then say, oh, and by the way, I also think this is an additional reason the parent's currently unfit, because now we have a problem. Now we have that there was maybe a necessary service that needed to be provided and wasn't. So there should always be this connection that you're looking at. If there's a deficiency, there needs to be a service that can help resolve the deficiency or something that's offered, if it's something that can be remedied with a service, right? If it is something where it's not a remedial service, that's a little bit different. Like you couldn't say, for example, this parent needs a 24/7 nanny, and then they'd be able to take care of their kid, right? Okay, so we're almost out of time here, but we have just ended the first step. So we took all of that. That's the first step in what's required to terminate parental rights. So you have to prove all those legal elements that we went through, A through F, and that the parent is currently unfit. And those elements have to be proven by clear, cogent, and convincing evidence. What does that mean? So clear, cogent, and convincing evidence is kind of between preponderance of the evidence and evidence beyond a reasonable doubt. So preponderance of the evidence is just slightly more than 50%, and beyond a reasonable doubt is beyond all reasonable doubt, so it's much higher. And clear, cogent, and convincing is in the middle of that. So it has to be higher than a preponderance of the evidence, has to definitely be higher than close to 50%. But then after all of that is proven, then the court gets to look at what is in the child's best interest. And the court also has to find that termination of parental rights is in the child's best interest, but it has a lower burden of proof for this element, just a preponderance of the evidence, just a little bit more than 50%. So the best interest element is really flexible, and it's very open compared to the rest of the statute, which I'm sure you kind of realize there's a lot of different like interpretations of all the different words in the statute and all the parts in the first step. And the paramount concern here when looking at the child's interest is the child's welfare and the child's right to a safe, stable, and permanent home. And that is, comes directly from the dependency statute, when the rights of basic nurture, physical and mental health, and safety of the child and the legal rights of the parents are in conflict, the rights and safety of the child should prevail. That comes from the dependency statute. And so that's really relevant to the best interest consideration. And I think a lot of you have, kind of been alluding to the best interests of the child, even in some of your questions as we've been going through the elements that are needed to prove before the court gets here. What I really want to emphasize is the court doesn't get to look at these aspects of best interest until all of those other elements and current parental unfitness are proven. So what are some things or some ways that you provide testimony related to the child's best interest? What are some things that you would look at?
What about, let's say the parent has neglected the child medically, child has distinct medical needs, and the parent still refuses to see those as necessary steps to take?
So how would you articulate that as what is the best interest of the child then in that instance? Like what
the best interest would be to receive the required medical attention.
Right. So it's in the child's best interest to have a caregiver who has the ability to understand, right, and implement necessary medical treatment for the child. Exactly. That's great. What are some other aspects of the child's best interest, or could be aspects of the child's best interest in a case?
This is Vicki. I would assume that this is the place where actually that parent-child bond would be the most significant, where if you're talking about a case where a child really has little, if any, emotional bond with the parent, but has a deep emotional bond with whatever the family, whatever home they have been in, whether it's relatives or foster family or whatever, that this would be a case where that would be an issue for the child's best interest.
Yeah, the child's like emotional health, bonding, why bonding is important, feeling safe, all of those things. That's right. Yes. I think we probably have time for one more person before we're done. Or not. So these are some things to think about. And again, just emphasizing that the court doesn't get to this aspect of the termination petition until all the other criteria are satisfied and resolved. So thank you very much for coming. This is one of the most engaged groups I've had during all of my online presentations during COVID. So it's been really fun for me. I hope that you left with some things that have been valuable for you and for your practice.